Okay, y'all, today we're talking about Greg Halpern's bankruptcy maneuvers and his attempt to evade the civil action. So the bankruptcy court issued a tentative ruling and a minute order to Harvey Vettri's team. So tentative rulings are not orders, but minute orders are court orders. So let's get into it. But basically, Greg, the shortcut is Greg lost. Here's the tentative ruling here, and here's a couple of important parts that I'm going to read out of it here. Neither an injunction nor an equitable removal of a director is a right to payment. So neither is a debt as the code defines the term. So Mr. Vettri can thus rely on pre-petition acts to form the basis for equitable relief, but he cannot seek monetary damages or other financial compensation for them. So basically what that means is that Harvey's team can use Greg's actions prior to the bankruptcy petition and as the basis for equitable relief, like removal of a director for cause. So basically that means full steam ahead and in the civil case. I'm going to read another little section here. As debtors' additional requests, it is inclined to deny them on the present record. Debtor impermissibly brought them through an opposition. So you can't bring, claims for relief through an opposition. You have to do that in a motion. So again, this is Greg. He can't litigate because he's an idiot. And there is insufficient foundation to grant an evidentiary hearing. So the court even denied him on the face. Without an opposition, they denied him. Nice. Good job, Greg. Your litigation prowess is unmatched. So, Mr. Vettri, so don't need an evidentiary hearing, enter an order requiring Mr. Vettri to obtain a comfort order for subsequent actions. So that means we don't have to seek any more comfort orders. This is it. And then we're going to go to the order. So this is the minute order, and this is a court order. And under disposition, second sentence, court made clear the following outcome: that it is not a violation of the discharge injunction to bring equitable claims that don't involve monetary relief, including claims that are rooted in pre-petition or pre-conversion past. So again, it means that we can use all of Greg's acts in the past as evidence to remove him for cause without seeking any further comfort orders. This court will, and second, the plaintiff in the state court cannot request monetary damages for actions pre-February 2nd, 2021, which we're not. So, what this means is that Greg lost, and I don't care how he spins it. He has to face up in the civil hearing, which is going to happen, and he's got to answer, because the next motion, he's not going to like it, and he's not going to like the outcome. But Greg, you lost, and because you're a loser. And for those who think that this is going to take 2 years to do, no, Greg, bro, in 60 days, you're gone.